Good morning, everybody. We're going to talk about Chapter 5 today, contracts, what makes a contract. And so let's take a look at, excuse me. Let me get over there. Okay, contracts in general. So basically a contract has to have three things. It has to have an offer, an acceptance, and then consideration or some type of money or something like that is usually considered consideration. So the contract is a voluntary agreement between two or more parties. It is legally enforceable. The contract can be express or implied, and we're going to talk about those two a little bit later. And you have to have the legal capacity to enter into the contract. So those are several items that have to be in play. A breach of contract is when either party fails to fulfill their part of the bargain. They didn't meet the agreement. And some of the remedies for breach of contract are called damages, and they can be money, they can be specific performance, or they can be an injunctive relief. And these are just different types of damages that you can do or receive as a breach. So think about contracts and what a contract would be to you. You probably have one if you've bought a car or a house. So you have a contract with them. If you are working and you have medical insurance, you have a contract with your insurance company. Are you employed? Then you have a contract with your employer. These are all just different types of contracts that are out there. Excuse me, my allergies are killing me today. So let's talk about the elements of a contract. And probably the two main items for elements of a contract are consideration and mutual agreement. Now, for any contract to be enforceable, to be a contract, there has to be something in exchange for what's received. That's consideration. So basically it says, I'll build you a deck on your house, but you have to pay me for it. So that's your consideration. Contract with medical could be the one between the patient and the physician. Then they're obligated to do something. The physician is obligated to treat you, to take care of you, and your obligation is to pay them for doing that. So the next one would be mutual agreement. That's the second element and part of that contract. And that means that you both agree. There has to be an offer and acceptance. And you have to agree that you are entering into a contract. So there has to be mutual agreement. Actually, let's talk about that mutual agreement for a few minutes here. Like we said, the patient-physician contract is one of those things that is mutually agreeable. The physician has to agree to treat you, and you have to agree to pay them for that treatment and to follow their advice on what they tell you. Do physicians have to take every patient that wants to be part of their practice? No, they don't. They get that choice. There are several things that physicians can refuse to do. I mean, they don't have to talk to somebody about something outside their specialty. They refer you to another physician. They don't have to make house calls. That's not a requirement. They don't have to have extended office hours or not take vacations. Things like this are all things that they don't have to do. So just remember that they don't have to do what you want them to do. They just have to have that set standard. All right, types of contracts. There's two different types, express and implied. An express contract is an actual written agreement. Well, it's written or oral, either one. It's put down in writing or orally, and it's has explicit language. It says what you're going to do and what you're not going to do. An implied contract is one where you don't really say it or do it. You just do something physically to show that you are in agreement. So, for example, if you are in your doctor's office and they want to take blood, if you throw out your arm there so that they can get blood from you, that is a type of implied agreement, because you are throwing your arm out saying, yes, I agree, go ahead and take it. Next thing we're going to talk about is capacity of the parties. So they have to be legally able to enter into a contract. If they have a legal disability, they cannot do it. If they are minors or incompetent persons, they are not allowed to enter into contracts. If it's done under duress or there's been some type of threat or undue influence, you cannot enter into a contract, and it's not enforceable at that time. Minors. So minors are not allowed to enter into contract, and a minor is anybody who's under the age of majority, and it's usually 18 to 21 years, depending upon the state. It just depends on where it is. Most of the time, it can be over 18. You can have mature minors or emancipated minors, and those are an exception to the rule if they are either one of those. Emancipated minors have actually gone to court and gotten their legal ability to make decisions for themselves. And mature minors are those who have been through so much, especially medical issues, where that they are considered able to make decisions on their own for their own medical care. All right, let's talk about mental incompetence. Mental incompetence does exist when a person doesn't have the mental capacity to understand what's going on, what their actions are, and the nature of the consequences for what they do. In this case, they cannot enter into a legal binding contract. Sometimes we will need somebody to represent them. That's called a conservator. And they are appointed to oversee their financial matters because they are not able to do that for themselves. They're usually appointed by the court system. Undue influence. What do you think that might be? Undue influence is when one party improperly uses some type of influence over the other party to cause their actions to not be in their best interest. When you could, with doing a physician, they could use their position as undue influence. And then that would break the contract. Now, an agency is also a type of contract. So this is when a person agrees to work for and under the direction of another. And so you have the principal, who's the employer, and the agent, who is the employee. So if you're looking at healthcare, we're talking about a hospital or a doctor's office as the principal, and the agent would be the nurse, the assistant, whoever it is that's working for the physician. Next part is termination of contracts, and how do you terminate one? And there are several ways this can be done. Most of the time, the physician is obligated to treat the patient unless the patient has given notice that they do not want to be treated by that physician, or discontinues payment or something like that. That breaks the contract because one party is not fulfilling what the other party needs. If a physician decides to terminate a patient, it has to be in a written notification by certified mail with a return receipt. Otherwise, it is considered illegal to just withdraw from a patient, drop them. You have to give notice. So, breach of contract. We just talked about that a little bit. Is when one party doesn't keep the promise. Some part of that agreement is not met. And these are all just types of breach of contract. So you'll see this when a patient doesn't pay their bill at a doctor's office or a hospital. That's considered breach of contract. If the physician actually does offer a warranty that they are going to make the patient cured, but is unable to do so, then yes, that would be considered a breach of contract also, unless there's negligence. But you will not see a physician ever do this, though, because they will try to protect themselves. Abandonment is when a physician terminates a patient, deserts them, does not do the written notification that they will no longer be seeing them. They just stop treating them, will not see them, and that's called abandonment, and it is illegal. So what's the statute of limitations? It all just depends, and most of it's based on what's called the discovery rule. The discovery rule is what is known as when the actual injury was found, and usually there is a year from that point. So who pays? The contract still is with the patient and the physician on treatment. The actual payment itself, or consideration, is actually with the patient and the insurance company, if there is one, or just the patient paying themselves. Managed care makes a few of those changes, but still that contract is there. Minors lack the legal capacity. They're not able to do this, so they can't enter into that contract. The only exception is with pregnant minors, and then they have control over what happens with their baby. Divorced minors and the single parent family. Now sometimes we run into differences because if there's a divorce, trying to determine which parent is liable. Is it both? One? Who carries the insurance? That type of information is something that you will need to be aware of. So when we're dealing with divorce and minors, what you run into is a lot of times the parent that brings the child in is not the one that has custody or who's responsible for payment. Just be aware of these issues. It could cause some problems down the road. All right, healthcare advance directives. We're not going to talk on this much right now because we actually have a chapter later on where we go over advance directives in detail. But these are extremely important. It's something you need to discuss with your family. Get these set up so that everything's taken care of, and we'll discuss that more. So just be aware that this is the Patient Self-Determination Act or Healthcare Advance Directives, either one, came into play to help protect patients. And there's different kinds. There's the living will, a healthcare power of attorney, or just a couple of them. You can also do other documentation on whether or not you want to be on any type of assistance. You can also look at whether or not donation is something you might be interested in. But we'll discuss these more. Just be aware that that is out there, and it plays a big part in healthcare, and we're going to be discussing that later. So let's summarize real quick. So a contract is a voluntary agreement, and it has to be between two people who are legally capable of doing a contract, which means that they are old enough, they have the mental capacity, and they have the ability to offer something in exchange or consideration. So you have to have the offer, the acceptance, and the consideration. Now the consideration can be money, or if we're doing a barter system, it could be you complete this for me and I'll do this for you, that type of thing. The offer can be written or oral, or it can be done by an implied manner. The express is a written or oral statement. The implied is when you actually show something, such as giving them your arm to take blood. That's without saying anything. That would be an implied. Let's see. Minors, incompetent people, those under undue influence cannot enter into a contract legally, and it will not be enforceable if it's due to any of those. Employees are agents, and their employer is the principal. If you're looking at agency law, contracts made that way. Once the agreement has completed and that consideration takes place, exchanges hands, the contract is terminated at that point because it is to be considered as completed. Let's see. What else we want to talk about? Breach of contract is when one party does not fulfill their obligation to that contract and what they do, and it can be considered breach of contract. And there are many different things that you might have to do if you do breach one. So you might have to pay money. That's probably the most common way of doing it, but there's different types of damages that can be levied upon you. Well, I hope this gives you a little bit of help with Chapter 5, and if you have any questions, let me know. Thanks.